Good morning. In the circumstances of some historical, testimonial, sexual assault allegations, it's conceivable that a failure to attend a trial may be germane to a material issue. Just not in the circumstances of this case. Oh, by all means. Just not in the circumstances of it. Should I start again? The problematic voir dire and the deficient instruction to the jury added prejudicial insult to a serious evidentiary injury. The evidence at issue was the difference between the hung jury on the first case, where this evidence wasn't called, and the convictions that ensued on the retrial.
There is a logical error, which is captured in the Latin phrase, post hoc ergo propter hoc. After the fact, therefore, because of it. The proposition you're putting to us is the only difference between trial 1 and trial 2 was this evidence, therefore this evidence swayed the jury. It doesn't hold up.
Well, I appreciate that is most certainly a law of logic, but it doesn't necessarily apply in these circumstances because it is, on the body of evidence, the only substantive difference between the first trial and the second. So while not ever being in a position to be able to say, for sure, this is the major contributing factor, it's impossible to say that it wasn't a significant one. The Court of Appeal, in our respectful submission, was correct. The respondent was deprived of a fair trial. And a bad trial remains a bad trial. The only remedy for a bad trial is a new trial. If it may please the Court, I will make my respectful submissions in 4 parts. And the purpose of our submissions are to respectfully address why Justice Hushcroft's decision was incorrect. Plainly, we will address, number 1, that the trial judge and thereafter Justice Hushcroft and the appellant at this court is urging a regressive categorical approach to after-the-fact conduct. Number 2, the respondent maintains at this court, as the respondent has maintained at all levels of court, that this evidence was inadmissible for the purposes of establishing consciousness of guilt. Finally, number 3, that the trial judge failed to assess the probity and the prejudice of this evidence. And I will just very briefly touch on that because I know that that's a question that was just asked. It's always possible to engage in some form of strange judicial archaeology to try to cobble together reasons. But one of the major things, if we look at the actual transcripts and appreciate what was being discussed as between counsel during this voir dire, you had a comparatively young trial lawyer asking the court to consider the relevance of this evidence if the chain of inferences was in fact available. And if that chain of inferences was in fact available, nevertheless, if it engaged an exclusionary rule, or if the probity was in fact exceeded by the prejudicial worth. At trial, a very senior Crown attorney was urging the judge to never engage in that analysis. In Volume 4, at tab number 31, page number 54, 52 in the actual transcripts, the Crown attorney at the time, my friend has said, and I say absolutely incorrectly, that this is, we recognize as a piece of circumstantial evidence, and that is a piece of circumstantial evidence that on a voir dire, the Crown must show on a balance of probabilities that its relevance exceeds its prejudicial value. That was very much what was being discussed at the voir dire. At the voir dire, on the first part of the voir dire, there was a discussion about whether or not there was any utility in hearing evidence from then the defendant, now the respondent. So the first decision was simply, well, I don't see any utility in hearing from the respondent or the defendant at all. And then the second was simply, okay, I deem this evidence to be relevant, but there was never any engagement at that level with, number 1, whether the alternative explanations that could be proffered could amount to explanations that were equally consistent with and therefore render the evidence of no probative value, Or, in the alternative, if the explanations that were proffered could take us into a situation where, again, during the voir dire, the trial judge had several decisions before him from the Ontario Court of Appeal, where, for example, an individual had allegedly absconded between the time of an accident and ultimately was arrested in Gibraltar. So that was a case called Davies that was before the court, and the trial lawyer for the defense at the time was urging the court to hear the explanations in order to consider if on the first hand this evidence could actually be deemed relevant for the purpose of showing that this person evaded because they had a guilty mind, and that guilty mind related to the underlying predicate offense. And then number two, whether or not there were equally consistent explanations that would otherwise render it of no probative value. The trial judge, on the one hand, decided, I don't need to hear from the defendant because this evidence is relevant, and it's relevant because, well, in 1998, Justice Major most respectfully said that sometimes, in some circumstances, this will be relevant. So there was a somewhat categorical approach in ushering in the evidence, and after that, the judgment very clearly only deals with, well, there's an arcangioly aspect to this, but I'm not satisfied that it's engaged. And then his ruling thereafter is a quotation or a citation with respect to Corbett. I'm saying all of this because the idea that there was a prejudice and probative analysis, it just didn't happen. The trial judge was being told, don't do it. I mean, it's right there in the transcript. The senior counsel is saying, you don't do that. Don't listen to what the defense is asking you to do. Finally, the fourth point that we will address, if time permits, is that respectfully, the trial judge's charge on after-the-fact conduct, when approached from a functional perspective, did not equip the jury with the necessary tools to render a true verdict according to the oath, their oaths, and the evidence. The majority of the Court of Appeal was correct, and most respectfully, this appeal should be dismissed. If I could begin by addressing what, in our respectful submission, erroneously informed the trial judge and thereafter has carried through into Justice Hushcroft's decision, and you can see it, paragraphs 51 and 52 of the dissenting opinion, this almost categorical and automatic admissibility decision, where it begins by Justice Hushcroft saying, plainly the appellant's failure to appear at his first trial was evidence from which an inference of guilt could be drawn. Well, why is that so plain? Beyond the mere act of not attending, there are several inferences that have to be drawn in order for that to be a logical chain.
Even if you use the word plainly, you said could be drawn.
I understand it.
Automatic.
By all means, but we're also informed by the following paragraph, which then says, Nordheimer J. does not say that this inference could not be drawn, nor could he. It is one of the examples set out by the Supreme Court in White. So very clearly, this is being categorized right from the get-go. And thereafter, when Justice Hushcroft says, at most he could have given an alternative explanation. Well, but that's very important, because it's for the trial judge, specifically the gatekeeper on a jury trial, to hear those alternative explanations and to determine, before it goes to the jury, whether those alternative explanations have the ability to negatize the sought-after inference. And here, when Justice Hushcroft says, at most there could be an alternative inference available, it seems, respectfully, that he doesn't appreciate what exactly those alternative inferences can do.
See, when I read that passage, I see the use of the conditional throughout. The appellant's failure to appear at his first trial was evidence from which an inference of guilt could be drawn. Nordheimer J.A. does not say the inference could not be drawn, nor could he. In other words, there's no categorical statement which can be made one way or the other. It's one of the examples in White where Justice Major wrote, and I quote, an inference of guilt may be drawn. It could be, maybe. It's saying that it is a possibility. It depends on the circumstances of the case. You're telling us that Hushcroft said it's always so, but that's not what he wrote.
Well, but isn't that the necessary inference when he suggests that at most an alternative explanation can be provided? Because that appears to not appreciate that the alternative explanation can actually be the coup de grace to this evidence at the voir dire. And I would say this most respectfully as well. This is not inherently a common sense inference. Jurors are by all means intelligent. There's no question about the abilities of our citizens. But it's not a common sense inference how people interact with the criminal justice system, their attendance and non-attendance at trial.
This, if there is an equally credible explanation, you said that renders it inadmissible, it deprives it of any probative value. Is it for the trial judge to decide that it's equally credible explanation, or would that be for the jury to decide?
It would be for the trial judge. And you would see this being implicitly referenced by the ability to give a no probative value instruction. Because that at all times vests in the trial judge the ability to remove from the jury's consideration a piece of evidence. So I would implicitly argue that if a trial judge always has that ability to look at a piece of evidence and remove it from the consideration of the jury, then that ability would necessarily exist at a voir dire.
But I guess the difference is between saying, I think this is an equally credible explanation, and therefore it has no probative value, or I think this must necessarily be an equal explanation, and therefore it's not admissible. What I'm trying to get at is, isn't it really up to the jury to decide whether it's equally credible as an explanation or not, provided it's capable of being seen as an equally credible explanation? I'm not sure that it actually is up to the trial judge to decide that.
And I appreciate that. I'd ask this court to consider the recent decision of Calnan, specifically, as I understood Madam Justice Martin's position with respect to this, that in most cases it will be for the jury to decide, or in almost all cases.
Right.
But that was not a categorical statement neither. So that suggests that there must be some cases.
I'm trying to ask you to give some precision around how you express that.
Well, I would suggest that given the frailties and the dangers associated with this type of evidence, that type of analysis does actually have to happen at a admissibility stage, because that's exactly what is being considered, amongst other things, when, for example, in Rogerson, we're talking about relevance has to be very specific and it has to be explicitly articulated. So one would think that at a voir dire in determining whether or not there's not only relevance, but there's no other competing arguments that would negativize that is all spelled out and decided upon before the jury is exposed to it.
You know, this is starting to sound more complicated than it really is. This accused had a choice to show up. He chose not to. He'd heard the evidence against him in the preliminary inquiry. He didn't show at trial. There's a logical inference that's possible from that. Now, how much weight you give to that jury, that's up to you. He says he was in dire circumstances, his surety had disappeared, and he was sort of an emotionally messed up state. Over to you. Isn't it as simple as that?
No, it's not, sir. And I would respectfully ask this court to consider a comparative parallel in the criminal code. We have sections 475 and section 803, whereby Parliament has sought to create procedures for when individuals abscond. So in the example of section 475, this is at page 15 and 16 of our factum, where an individual in a superior court matter absconds in the face of the trial judge, the mere act of not remaining is not automatically lead to an adverse inference. There's actually a requirement that there is some determination that the failing to attend at that point is done for an evasive purpose. And that's in many ways tied into what Justice Pacheco is discussing in his oft-quoted article, that it's dangerous to move simply from one act to the ultimate conclusion, which is exactly what this type of evidence is. It's trying to infer guilt by inferring guilt. We're saying that this gentleman did not attend at his trial, and his failure to attend was because he was consciously guilty of the offense, so he's consciously guilty of the offense. But there has to be something in the act itself that permits that additional synergistic inference. So you look at cases like White, it's not just the flight, it's the absence of hesitation that speaks to a live issue. Here, the mere act of attendance or non-attendance, because there are so many reasons why people might react in a nervous or anxious way to stressful situations, it becomes a bit of an untutored stereotype to assume that guilty people would not attend and innocent people would attend. Your Honor referenced logic, for example. Well, one of the rules of logic is that for any true assertion, it should be subject to the contrapositive, which is that you take the hypothesis and the conclusion, you reverse both, and negate them. Well, is it true then that guilty people don't attend their trial, innocent people attend their trial? Well, then why are there so many convictions when people attend trial then? There has to be something additional in the act of attendance or non-attendance that allows that inference. And this is exactly why these paradigmatic examples that Justice Pacheco invokes in his cases are invoked to suggest these are particularly dangerous. Look at the judicial experience that we have in cases that deal with things such as demeanor evidence or false alibis. It is not just a false alibi that allows you to make a negative inference with respect to it. You need something additional, some extraneous evidence to suggest that it's concocted, and then you can reach the kind of negative conclusion. But on its own, I would ask this court to most respectfully consider, for whatever this court feels that it's worth, Justice Pacheco's article, particularly at page 14, and this is in the Appellant's Book of Authorities, tab number 1. If I just give you an opportunity to get there, and I would read oh, I'm sorry, I said 14. It's page 15, please.
We don't have the books of authorities.
Oh, you don't? Well, then...
You don't have a condensed book, do you?
No, I don't. I was just relying on the Crown's Book of Authorities. I'll just do my best dramatic reading then, if I may. To understand how the fortunes of an inference offered for a discrete piece of evidence is to be assessed in light of the evidence as a whole, take the mundane example of an invitation by the Crown to infer that the accused person left the jurisdiction in order to avoid detection. Relevance depends upon inferring a causal link between the departure and the flight. If the evidence, in totality, shows a significant delay before departure, the inference may not follow logically. Or, if there is evidence of other equally plausible explanations for the departure, it may be impossible to infer reasonably, rather than arbitrarily, that the flight was connected to the alleged offense. That is, of course, an article, and it's not binding in any way, but it's a discussion of some very parallel principles to those that are engaged in this case, in our respectful submission. And some of the facts that were drawn to this court's attention in the course of my friend's submissions, with great respect, were a little under-inclusive. Because what you have is this gentleman, when he was told that there were outstanding charges, this is somebody who was from Calgary. He moved back to his home. And then he flew back and surrendered himself to process. And after that, flew back and attended for a preliminary inquiry. And after that, presumably, retained counsel to attend a Superior Court judicial pretrial and to argue pretrial motions, 276 and 278, for which his attendance was not required. So to actually say that he heard these allegations and then tuck-tailed and ran, that's totally non-responsive. Then why did he continue to inferentially retain counsel beyond the preliminary inquiry? And then what you actually have is the factual break in any kind of causal argument, which is, oh, the surety did revoke. That was exhibit number 2 at trial. Exhibit number 1 at trial was the recognizance of bail. So the surety revocation is directly responsive to thereafter his not attending. In our respectful submission, that's very important because on the one hand, if you're going to suggest that failing to attend thereafter is consciousness of guilt, then amongst other things, In failing to put the alternative explanations to the jury, the trial judge also unfairly failed to put the consciousness of innocence to the jury, because wouldn't it be consciously innocent for somebody to surrender themselves to a process, to attend a preliminary inquiry, to retain counsel for a superior court judicial pretrial? These are all acts necessarily that would constitute some evidence of innocence if, as we said, failing to attend is somehow to allow you to make this inference of guilt. Those things are never put to the jury. So going back with the time that I remain to this categorical approach, well, that's why the trial judge was just ushered into making a decision, and that's why the majority, respectfully, at the Court of Appeal said it appears as if this trial judge simply operated on the basis that if there was some relevance, it was thereafter admissible. And even by the trial judge's own admission, there was a modicum of relevance here, a modicum of relevance.
But you suggested to us it was decisive. That was your opening, that this was what tipped the balance and got your client convicted.
Well, but those are slightly different propositions, because
They sound very much the same to me. That's either important or it isn't important, and you've told us it's of great importance.
I disagree, sir. A modicum of relevance suggests that the evidence that was being tendered had a slight tendency to support the proposition for which it was being offered. Once that evidence was admissible, however, and it wasn't properly the subject of an instruction, it became quite, I would respectfully submit, impactful for the jury's considerations. So on the one hand, it relates to what the judge is saying as to the admissibility of the evidence, and the other is what impact this evidence would have once it's in and not properly controlled. What we needed was an instruction akin to that in Rogerson, where if this evidence is being adduced for a very particular purpose, shouldn't the jury have been told the very nuanced way in which the inferential link could be followed, and correspondingly, the way in which the link could be followed to otherwise negatize this evidence? None of that is done here. This is a very deficient instruction with the greatest of respect. At best, it amounts to a caution, but it's not an instruction.
Can you then identify, since that seems to be key, having let it in, and your position is it's not relevant, it shouldn't have been let in, but having been admitted, what do you say the charge should have said in order to bring it into compliance with the jurisprudence?
The Ontario Court of Appeal, the majority's decision did, I would suggest, fairly set out what would have been appropriate. And we are joined today by the CLA as an intervener, and we would adopt as well what they suggest in terms of what is an appropriate instruction in this case. Very specifically, though, because we submit that what needed to be done was as follows: that the jury would have to be told about the law on drawing inferences. Thereafter, relate the evidence to that law. Then summarize the available evidence. Explain the logical chain from evidence to conclusion. That's right out of Callahan, paragraph 115. The law on alternative explanations, and not just relate those explanations available on the evidence, because there's also judicial experience that assists in telling people that there's a myriad of natural reactions to stressful situations. And again, the intervener has very carefully, I believe it's at paragraph 17 of their factum, set out various examples at the Ontario Court of Appeal where not only was the specific alternative explanation provided, but hypothetical explanations, just to ensure that this evidence isn't improperly used. And based on my understanding, one of the reasons why the instruction is so important that it's properly done is because we have to understand this evidence conceptually. When White was decided, that was a time when there used to be a higher burden to admitting this evidence. And instead of keeping that higher burden and to not contradict Moran, they said, you know what? We're going to let this evidence in on the regular kind of admissibility analysis, but the heavy lifting will thereafter have to be done at the admissibility stage and at the instruction stage. So we have to see a fulsome consideration. Getting back to your question, I'm sorry that I deviated. The law on alternative explanations, and then relate the evidence to that law. Summarize the available evidence and any available logical common sense alternatives, and There may need to be the cautionary conclusion. And finally, any other explanations or cautions that are warranted. For example, in this case, this was bad character evidence. It was evidence of a criminal offense that was on his criminal record. That is one of the most important points that has been argued at all levels of court, but there has never been a satisfactory answer from our respectful position, that where evidence engages in exclusionary rule, that exclusionary rule should operate. And so we would adopt, for example, what the majority of the Ontario Court of Appeals suggested with respect to an additional instruction should there be bad character evidence involved in this after-the-fact conduct. Does that fairly answer your question? I'm sorry if I can just have a brief indulgence. We'd also like to address in the very short time that remains the Crown's argument and ultimately Justice Hushcroft's position that there ultimately was no real deficiencies because, well, in part of the instruction there was defense counsel's position, and defense counsel's position provided the alternative explanation. There is little authority, perhaps only the Ontario Court of Appeals decision itself, that says that there's a realistic approach to this, and it's very different from a trial lawyer telling a jury something versus the judge telling the jury something. And where the jury was told about this is also of great significance, because previously you were asking, I believe, Your Honor, or Madam Justice Abella, about, well, where did this happen? It was so far removed from the actual instruction that it was tantamount to being non-responsive. And even where it was included in the instruction itself, no party, no one ever actually was able to hit the nail on the head, as they say in Rogerson, and explain to the jury how this evidence was relevant. That inferential chain that we say is so important. Where was it succinctly and easily articulated for the jury to be able to follow? In our respectful submission, as stated at the outset, this was very prejudicial evidence that ought not to have been admitted. And while it's impossible, of course, to say that it was the only contributing factor, because of it being the only substantive difference from one trial to the next, on the first trial, 12 citizens trying the case on their oaths and on the evidence could not come to a unanimous decision. It seems as if the tiebreaker really was this evidence, left to their careful considerations without proper instructions. In our respectful submission, that was an error, and that's why the Ontario Court of Appeal most respectfully was correct, and the only remedy for a bad trial is a new trial. Subject to any other questions, those are my most respectful submissions.
Thank you, Mr. Johnston.